Before we can form an opinion about education, we need to examine several things, like why and how the public school came into existence, the Constitution and amendments, and the laws that have been formed since.
In colonial America, the earliest education laws required training in skills and trades through apprenticeships for orphans and needy children. By the 18th century, laws had been expanded to include training in reading and writing. Teaching children the skill of reading enabled religious instruction and reading of the Bible.
Forcing everyone to receive a public education is like forcing everyone to receive welfare. Public education was made for the 20% of children that were poor. To force families that didn't have that need in that area would have been absurd. Welfare is for poor people, just as the first schools were made for the poor people. Most people didn't need the state's help. In fact, when Massachusetts became the first state to adopt a school attendance law, the United States already had a higher level of literacy than it has today.
The first compulsory education law was enacted in 1642 by the Massachusetts Bay Colony. This law required parents to provide an understanding of the principles of religion, reading, writing, and a trade to children under their care. Other colonies adopted similar laws between 1642 and 1705.
At this point in history, the laws are not violating parental, religious, or constitutional rights. All the laws that are in effect are things that parents should be doing for their children anyhow.
Support for the compulsory education declined during the 17th and 18th centuries. In 1852, the Massachusetts School Attendance Act of 1852 specified that children had to attend school. Although unclear and ill-defined, exceptions were included in the law, as were penalties for enforcement. The early laws were vague, and some parents resisted. By 1900, court cases had affirmed state enforcement of compulsory attendance laws based on the benefit to the child and the welfare and the safety of the state and community. In 1901, the authority to mandate school attendance was expressed in the Indiana Supreme Court opinion for State v. Bailey. The findings state that the welfare of the child and the best interests of society require that the state shall exert its sovereign authority to secure the child the opportunity to acquire an education. In 1994 case of Prince v. Massachusetts, the U.S. Supreme Court declared, acting to the guard of the general interest and youth's well-being, the state may restrict the parent's control by requiring school attendance, regulating or prohibiting the child's behavior, and in many other ways.
As you can see, it has only been in about the last 100 years that constitutional rights, religious rights, and parental rights have begun to be violated. Thankfully, there have always been exemptions along the way.
According to G. and Sperry, compulsory attendance laws must meet the demands of reasonableness. This term was defined in the U.S. Supreme Court case Pierce v. Society of Sisters. The state of Oregon required that children attend public school only. The court decided that the statute was unconstitutional on the basis of violating the 14th Amendment rights of the parents and the property rights of the schools.
Wisconsin v. Yoder. Amish religions objected public schooling beyond the 8th grade. The Amish had experienced conflict with state authorities over compulsory school attendance over the years, but instead of litigation would pay fines, be subjected to short-term jailings, or move. Amish parents appealed the decision of the court that convicted them for violating school attendance. The state justified the conviction, but the Wisconsin Supreme Court reversed the lower court ruling. They found that Amish could convey the social and political responsibilities of citizenship without compelling attendance beyond the 8th grade, at the price of jeopardizing their free exercise of religious belief. The United States Supreme Court upheld this decision in 1972, with Chief Justice Warren Burger ruling, "A state's interest in universal education is not totally free from a balancing process when it impinges on the fundamental rights and interests, such as those specifically protected by the Free Exercise Clause of the First Amendment, and the traditional interests of parents with respect to the religious upbringing of their children."
It's not just Amish objecting to the school system for freedom of religion anymore. According to the Homeschool Legal Defense Association, many Pennsylvania school districts have allowed the Pennsylvania Religious Freedom Protection Act, or the Rfpa, to be used for homeschooling. The families that use the RFPA are thankful because otherwise they would have to abide by Act 169. That act has caused many people to consider Pennsylvania to be one of the hardest and most burdensome states to homeschool in. Under Act 169, Pennsylvania homeschoolers have to give a notarized affidavit showing what they will be teaching for the year. They have to follow the state's guidelines, and at the end of the year they have to submit a portfolio which has been approved by a certified teacher and then approved again by the school district. Many religious people feel this is a burden because they know that they have to answer to God for the upbringing and schooling of their children. By answering to the school district, many religious families feel they were replacing God's authority in their lives with the state's. In the beginning of the public school history, everything was centered around God. Many Christians know that God, along with the Bible and prayer, have been kicked out of the school. Religious families cannot answer to a godless system for their child's upbringing. The argument is made that schools want to prepare children for employment and economic success and also to develop values and the character traits needed for citizenship. The Center on Education Policy makes the case that public education is essential not only in teaching the principles of democracy and the role of government, but also in promoting civic values and philosophy of tolerance for diversity and respect of differences in race and religion. But exactly what is tolerance? Diversity? Respect to race and religions? Does tolerance for diversity and religion mean that our children and parents can't opt out of gay pride months, or birth and sex education classes, or even the school giving out free contraceptives? What about the kids who get in trouble for reading their Bibles and wearing Jesus t-shirts? Some schools are getting new homosexual promoting curriculums that parents and children can't opt out of. Some of them start as early as kindergarten. How long till homeschoolers have to read a book about two kings to their children like the one read to second graders in Massachusetts? While there are many good teachers, principals, and school officials out there, it's easy to see why parents feel the need to ask for freedom of religion under the RFPA Act. Many religious families feel it's wrong to have to get the permission and approval from the school system to do something that God has already told them to do.